So I actually have two questions. One of them will follow up on just the previous comments. And I work mostly in the patent area, and so one of the issues that I've been toying with is the effect of Twombly and Iqbal, specifically on inequitable conduct pleadings. Because it seems to me that usually the way inequitable conducts work is so-and-so didn't disclose X to the patent office, and then of course it's a two-pronged issue, non-disclosure and then, and then sort of mens rea why they didn't do it. And so that seems to me, usually you can't get to the second prong without discovery. And so it seems to me that under Twombly and Iqbal, this very well may be conclusory. And so, I just would like to hear your views on how that will play out in the patent context. And then the second unrelated question is to Professor Thomas is, in your comparison between the old common law and today's motions, did you take into account, and if so, how, the fact that A, they didn't have really notice pleadings, and B, they didn't really have discovery. So when the courts ordered new trials, you could sort of keep bringing in more and more evidence until you got it right or the jury believed the other guy. While here, because we do have discovery, you know what the evidence will be at the second trial as well, and so it doesn't make sense to keep submitting to the jury if at this stage the court found that their evidence is insufficient. How does that sort of play out?
I'd like to take a crack at the first question. As a theoretical matter, I think you've identified exactly another sort of case where Twombly and Iqbal might likely have bite, because it is exactly like a civil rights case in the sense that the plaintiff is alleging a particular state of mind of the defendant and cannot have any evidence of that. But I think what that does is highlight the discretion that is given to the district court judges. I would not be surprised to find that the patent cases are not dismissed at a higher rate, whereas the civil rights cases might be, because I think a lot of this, especially with the word plausibility or plausible, even if the Supreme Court didn't mean it this way, judges are going to have in their heads, is this complaint plausible? Do I believe that this was done out of a discriminatory motive? Do I believe that most employers have discriminatory motives, or government agents, or whoever it is who's the defendant? As opposed to, do I believe that patent applicants have the mens rea of knowingly not disclosing? And I think that is going to turn on the judge's view of the world, and that's a terrible kind of discretion to give lawyers.
Yeah, note in that regard that a very interesting article published in the Harvard Law Review early this year by Dan Kahan and some colleagues on the Supreme Court's summary judgment decision in the video police chase case, where they develop a concept which I was pleased to see was identified by the New York Times Magazine as one of these interesting new ways of thinking, called cognitive illiberalism, which is a fancy academic term for what Suzanna just described. A lot of judges don't have the life experiences that will allow them to regard as plausible that which a number of Americans who don't have the sort of privileged backgrounds that they have experience every day. And it's one of the really insidious possibilities of these decisions, is just feed right into the fact that our judges don't, many of them, don't have the life experiences that are coming before them in court, and that the trial process serves to discipline. And that's one of the things, if you read the history of the jury trial, if you hear some of the things that were said in the 19th century cases about wonderful things in anticipating this problem of how the evidence actually disciplines the priors that the judges would have about these cases. So, and note finally about fraud, that I don't think anybody questions that the court acted lawlessly in disregarding, writing out of the federal rules, Rule 9b, which says that fraud, among other things, and states of mind can be averred generally. And if there's any doubt about what the people who wrote that rule intended, it's settled by their note, because their note refers to the English rule, and the English rule makes it quite clear that it means what it says. You don't have to plead any facts when you're alleging a state of mind. And they simply disregarded that. Because if they hadn't, they wouldn't have been able to reach the result. And I agree in some respects with Adam's take on this. I mean, note that they rewrote the law of official immunity, even though the petitioners had conceded some form of vicarious liability. They conceded it, and nonetheless, the court couldn't have reached the result it did unless they'd rewritten the law of official immunity. So if you want to find a teleological decision, Iqbal is it.
Yeah, and if I could just add to your first hypothetical about the patent case, and I think that this is how my approach would handle the state of mind issue. In Swierkiewicz and in Iqbal, it wasn't the fact that the state of mind was alleged in a conclusory fashion. That doesn't make something transactionally conclusory, and that's consistent with 9b. It's okay to allege state of mind generally. The problem in Iqbal, and it was not a problem in Swierkiewicz, was the failure to adequately identify what they did with that bad intent. It was the ambiguity about what exactly Ashcroft and Mueller's role was. So I think in the patent context, the way you'd want to argue it is to say, I can allege this state of mind generally, and here's what they did with that state of mind. They failed to disclose X. And I would say that would be non-conclusory, ergo it has to be accepted as true without regard to plausibility, without regard to whether there's actually proof yet.
And going to the other question, what I did was I looked at all the different common law procedures and then sort of as I sort of said in the presentation, looked at the modern procedure and compared them to the common law procedures, but then also derived what the substance of the common law was. I didn't import sort of what we do under the modern system. And the reason I think that that's appropriate is that, you know, the Seventh Amendment is the only place in the Constitution to refer to common law explicitly. And certainly the Supreme Court has said that, you know, originalism applies generally in the context of the Constitution, and has used it a lot, and he's used it a lot, especially in the context of the other jury trial provision, the Sixth Amendment. And I also sort of say that you set up in the Seventh Amendment sort of this division of power between the jury and the judge, and if it isn't something that's sort of somewhat set in some form, then you know, it's more difficult or more easy for judges, in fact, to sort of impinge or to impede on that power. So that's why I sort of start with the common law. I think there can be criticisms clearly to that, and I think some of what you're saying goes to that, where you could say, well, we have this modern procedural system that has deviated somewhat from, you know, this common law system, and so therefore don't we have to go around that? And I think that there's definitely something to be said about that, but we're so far from the common law system, given and what we actually have as our mandate, that I think we need to actually go back the other way before we kind of worry too much about the modern system.